Good morning. My name is Liz Weigenfeller. I'm the Executive Director of the Pennsylvania Office of Open Records. I'm joined by my colleague Dylan Davini, and we are going to talk about all sorts of things in terms of the right to know law and law enforcement. The way this works is Dylan and I always take turns going over the content. If you have a question during the chat, that sort of, you can put it in there or try to get to it, but things move kind of fast. So if you can wait till the end, that's probably ideal, but do whatever works for you and we will try to move forward. Edward, I'm sorry you can't hear. I think others can hear. So maybe see if something on your end is not clear. Okay, so lot to cover. I'm going to start. And I'm going to start with a story about an agency that maybe did handle a right to know request the most ideal way, just to show you how the way you handle requests can sometimes become the story. In this situation, this webinar, this mouse I need. Okay, a school district received a request for the video recording of an alleged incident on a school bus. There was a camera on the bus, and the district just did not grant access, and it appealed to our office, and we said this is something that should be released. They fought that, and they fought in the courts for almost 7 years to prevent the release of this video. And at some point, the court finally said, you've got to turn this over. This is a record. You can blur out the students' faces so that they can't be seen, but release the record. So when this happens in our little corner of the world, we get kind of curious, like they fought for a long time. What is this going to show? It must be something pretty scandalous. So the news media outlet that requested the records did a story, and it turns out the video showed nothing. The alleged incident occurred off camera. It's very dark. It's at night. Not a lot to see there. So we thought that was the end of that. And, why did they fight this? But then someone did a right to know request for the legal invoices associated with the 7-year court battle. And that showed that the school district paid $250,000 to fight the release of this video that ended up showing not much. That's a lot of money, and you better believe at that point every local news outlet covered the story, because that became the story, that they spent so much money. And this is an example, not to say you shouldn't fight the release of records. You absolutely should, particularly in your area. It is something that is important to understand. There are certain records that should not be released. It's just to show that understanding the law, understanding how a story could get out of hand is something to take into consideration when you face some of these requests. And we're going to go through kind of the basics of the right to know law. We have a much longer training we do about the nitty-gritty of a request, but because we want to cover a lot of law enforcement stuff, we're going to cover a little bit about the basics of the right to know law, go into specific things about law enforcement, and talk about some tips to try to avoid situations like this.
Okay, so I'm just going to get started here with a little bit of the, like Liz said, some of the general discussion, basics of the right to know law and things like that to get us started. So to begin with here, just sort of in general, the purpose of the right to know law is to give the public access to public records, to foster transparency, public participation and engagement, and therefore accountability for agencies through that transparency. So that's the general purpose of the law. The basic outline of the procedure is that it begins with a requester will file a request to an agency seeking records that they believe are public. If the request is denied or partially denied, or the agency fails to respond, or there's some fees the requester objects to, whatever the concern is, their next step is to file an appeal to our office. If they are still unsatisfied with our office's determination, or indeed if the agency is unsatisfied with our office's determination about whether additional records need to be released or not, they can then appeal to the courts. So we, in that process, are kind of an intermediate stage before the courts if needed. So one of the key aspects of the right to know law request procedure is the response deadline. So when an agency receives a right to know law request, it must respond within 5 business days of the date of the open records officer receiving that request. And that response can be a grant providing the records. It can be a denial indicating that the records are not public or that they don't exist or some combination. And the agency can also invoke a 30 calendar day extension to consider the request and prepare the response. And just to be clear, because sometimes it can be a question, that 30-day extension period will then begin after the 5 business day response window. So those are the options that an agency has when they are responding to a request. So when a request is appealed, that can be done within 15 business days of the denial. The requester can, of the mailing date of the denial specifically, the requesters can appeal redactions, which do count as denials, as well as things like fees, like I said. Those can be appealed to the Office of Open Records. And then the requester is not required to present evidence or argument. The burden is on the agency to defend the denial. So if an agency is citing an exemption category, or they're arguing that a record does not exist, or whatever the case may be, the burden is on the agency to substantiate that in the course of the appeals process. And so then the OOR has 30 calendar days by default to issue a determination granting the appeal, denying the appeal, however it goes, to sort of outline what additional steps, if any, the agency needs to take in terms of providing those records. So in general, it is good for the agencies to set up advanced policies and procedures on how those requests will be processed and have those things clearly posted on their websites and things like that. But just to be clear, there are some limitations on that. An agency may not adopt a policy or regulation which limits the number of records that can be requested or made available. And you also cannot require a requester to disclose the reason they are seeking the records or what their interest in the records is. You know, when you're determining whether or not a record should be released under the right to know law, for the law's interest, the primary concern is whether or not the record is public or not. So who the requester is, as long as they're, a legal U.S. resident and everything like that, who they are, what their interest in the record is, are generally not considerations in that process. So to sort of talk a little bit about some things that are generally not required of the agency in this process, you are not required to create a record that does not exist. This can, obviously this can be all sorts of things, but it can't be, a record that may exist in the future or things like that. You can't be required to create a record that doesn't exist. You're not required to answer questions. The right to know law is a procedure to request records, not a procedure to get answers to questions. A requester cannot require an agency to conduct legal research. And in addition to this, an agency is not required to provide an electronic copy of a record if only a hard copy exists. So if you receive a request for something that you only have in hard copy, it can be sufficient to provide just another hard copy of that, potentially with associated fees and things like that. So something to keep in mind is that whether or not something is a record for the purposes of the right to know law really pertains to whether or not it, documents a transaction or activity of the agency. It's about whether or not it pertains to agency business. So that's the primary consideration in whether or not something is a record. Whether or not something is on a personal account versus an agency account, or what the format of the record is not what determines if it's a record. It's whether or not it covers agency business. So obvious things like invoices or memos, those sorts of things can be records, but so can text messages, emails, including on personal accounts, Facebook, social media messages, video and audio recordings. Those things can all constitute agency records. So it's important to keep that in mind, both when you are, determining what kinds of things to create and to retain, and also how to respond to requests that you do receive. So just for an example of a situation where some caution may be warranted, this is a Red Rock. This is a music venue in Colorado that is owned and operated by the city of Denver. And they had a situation where there was a pretty bad hailstorm that had led to some injuries. And there were some members of the staff on that agency who maybe created some records that they maybe didn't want to have created that were ultimately produced in response to a public records request under the laws and procedures that they have out there in Colorado. And like I said, this can be implicated even if this is on a personal device, things like that. So these are things to keep in mind when you're creating, when you're preserving records and things like that. So when you receive a request, you can sort of follow a chain of logic here to determine what steps need to be taken. So first, you can determine, does the record exist? Is this something that we have? Is this something that we have from our contractors or our staff or something like that? Then you can determine, is it a record of the agency? Does it document agency business? You know, even if I send a work email out to my coworkers saying, where do we want to go for lunch? That may not be pertaining to agency business, even if we have it on our email accounts here. And then finally, you want to determine, is it a public record? Is it covered by any of the exemption acts of the Right to Know law or the exemptions of the act, or is it protected and as confidential by some other law or regulation or something like that? And then if it sort of passes all of those hurdles, then it can be subject to provision in response to a request made under the Right to Know law. There are certain things that are generally public. I never want to be definitive because there can always be all sorts of edge cases, but in general, financial records are generally going to be public. You know, the agency has an interest, or the public rather, has an interest in how agencies are collecting and dispersing taxpayer money, and that's a pretty straightforward one. And aggregated data is generally public. So while there may be sort of sensitive things about specific cases, and particularly as pertains to law enforcement for the audience today, you know, there can be things that are sensitive. Generally speaking, aggregated data is going to be a public record. There are, of course, you know, limitations to this and things that can come up. So there was one situation several years ago where someone had the pretty clever idea, I honestly think, that they may be able to obtain the playbook for a rival high school football team through a public records request. Because after all, you know, the coach was a school employee, or so the rationale may have gone. But ultimately, the determination was made that the preparation of that was not related to a governmental function. So even though maintaining the sports team was a governmental function, the playbooks of the high school football team were not covered under that. And so that was not a public record. So, you know, those are these sorts of things that can come up in all kinds of situations. And there's always a new question to investigate. But in this case, that was not ultimately considered a public record. All right, so having now gone over some of the sort of general rules and everything like that pertaining to the Right to Know law, I can now turn things back over to Liz to start talking about some law enforcement specific issues.
All right. Law enforcement and the Right to Know law. You all work with a unique aspect of the Right to Know law because there are a lot of records that are exempt. And also, as I will show, Pennsylvania is kind of unique in this world because of the lack of the limited access to certain types of records that other states seem to offer all the time. So first, I want to go back and talk about, I am not good at this mouse. Hold on. All right. Okay. I'm giving you an advanced viewing of these exciting slides. Okay. So I want to start with what's been going on in the world here. We saw an a very significant spike in appeals. So we hear the appeals here at the Office of Open Records, and over 95% of requests that are given to any school district or police department or state agency, township, city, all of that are not appealed. So we see just a tiny little fraction of requests, very, very small. And we saw a significant increase in these appeals last year. We've been seeing like a little bit of increase every year, but then last year, it was very significant. And to further underscore that, we really kind of felt like in 2025, the first part of the year was kind of okay. And then the second part of 2025, it sort of exploded. And it went from 1,400 to 2,300 appeals If you compare the most recent 6 months to the previous 6 months the year before, 62% increase, just a significant increase. And some news that will not surprise you perhaps is we are seeing it's because of artificial intelligence. This is where we are seeing why we are seeing this increase. And this is happening for several reasons. One, people are learning about the appeal process and the right to know process because of AI. You know, they get denied a request and they submit something saying, they say, I got denied. Let me put this in ChatGPT. What should I do? And it says, hey, did you know that there's this free thing you can do called the appeal process? And this Office Open Records. So we are seeing a huge increase in this use, and AI is not going anywhere. It is something that is going to be more and more entwined in everything that we do. And we are starting conversations on how to wrap our heads around what we can do about this, but it is something that is being focused on a lot. There have been articles about it. I spoke at a hearing about it in front of the House yesterday, the Pennsylvania House. So if you're starting to see this, you're not alone. I even talked to somebody who deals with records requests in the UK, across the pond in Europe, and they're seeing this as well. And let me just go back. One thing is that a lot of this is being seen in police departments. We had a huge increase in appeals in police departments, over 50% increase. So you all may be seeing that as well in your requests. That's kind of the little appetizer for what we're going through in terms of the way it works for police departments and other law enforcement. So one big difference is if it's a request for criminal investigatory records and someone's appeals and denial, that goes to the district attorney. We don't handle those, but all other appeals that you all may receive would come to us. Here's the common things we see requests for, and I did a little red light, green light, yellow light. For green being always public, such as police blotters and incident logs, department financial records, excuse me. Yellow means maybe. Policies and procedures, mug shots, that's a recent development, information on individual officers, shift rosters. Those, it depends on the details. And then vehicle incident reports and other accident reports and incident reports are not public. Vehicle accident reports are, it's because of another law, but those are not public, and incident reports as well. And in terms of what's not public, here's common reasons for denial we see. So we have other laws like the vehicle code and CREA and other laws that have nothing to do with the right to know law that prohibit the release of certain records you all may interact with, meaning you could actually perhaps get in trouble for releasing them. And the right to know law has 30 exemptions. An exemption means it's not mandatory. If you want to hand out those records, you can, but you can exempt them if you'd like. The ones we most commonly see for police departments and other law enforcement are criminal investigatory. That doesn't include the blotters I mentioned, and incident reports are considered investigatory. So that's why they're under criminal investigatory. So you can deny those. Non-criminal investigatory. That is things that, those are things like maybe HR investigations or other kind of things that don't have to do with crimes, but you're investigating something within your agency. If it poses a security threat, of course, you shouldn't release things that pose a security threat. That's a common reason records are withheld. In Pennsylvania, emergency dispatch recordings are exempt, and certain personal identification information is always exempt. You're not getting anyone's social security number or personal phone number or any of that. And then one common thing we see is, particularly back around 2021, we saw a lot of these. People wanting policies and procedures. And those depend. A lot of common one we saw was use of force policy. And most often they look at security exemptions and they say this for security reasons, we can't share that. And as you will learn, and your attorney, your solicitor will probably say, you can't just say, hey, it's a security exemption. You must prove it. So there was a case, I put a quote, where the city did not demonstrate the disclosure of SWAT team policies and procedures is likely to threaten public safety. So you want to make sure that you don't just say it, you have to prove it. I like to give the example, if someone was accused of robbing a bank, they can't just go up on the stand and say, yeah, I didn't commit that robbery, that wasn't me, and get off the stand and think that that's enough. You have to demonstrate that it is, you have to provide some proof in your written statements to our office. Shift rosters, that was a common one. We don't see those as much. We often see security exemptions cited. It's very case specific, but they're often, I've seen a lot of times that's been successfully done. An example we gave, there was a request for name, shift, duties, and total hours of all police officers that worked on a date. The city demonstrated a security threat for most of the record, but must disclose the names of the officers on duty that day in that situation. So if you get a request for shift rosters, I'd suggest going to our website. We have every case we've ever decided and putting shift rosters in our search. You can probably get some good examples of those who successfully denied a request for shift rosters or those that were not successful. All right, mugshots. This is a big development last year in our world. Previously, mugshots were very much considered public. They were in that green category. But then a Pennsylvania Supreme Court case changed all that. And there's kind of three categories to discuss. Non-law enforcement agencies, such as counties, are prohibited from releasing mugshots under CREA. 2, Pennsylvania State Police may disseminate mugshots and other criminal history record information for a fee outside of the right to know law, not through that mechanism. Other criminal justice agencies, such as police departments, may disseminate only as they deem necessary to carry out their law enforcement function. So it's their discretion. This is all I'm going to say about these because it is so recent. We don't have any case history, and I just want to hesitate to say anything more. But just know this was a big change. So mugshots there's more discretion at the criminal justice agencies about whether or not to release them, with counties and the state police having a little bit of a different situation with those. So big change there. Act 22. Another way Pennsylvania is very different. So Pennsylvania now has limitations on mugshots, and since 2017, it is more challenging to get dash and body camera footage compared to other states. Most importantly, it's not covered by the right to know law. We, the Office of Open Records, have nothing or no jurisdiction over dash and body camera footage. It must be requested within 60 days of the incident, the alleged incident. And the police department must respond to that request within 30 days, can charge reasonable fees for that, and the appeals go directly to the court, so they don't go to anyone else. And this is something that is different from a lot of states. If you go on TikTok or Instagram, if you get a certain algorithm, you can see constant body cam and dash cam going on from all sorts of serious things, allegedly amusing things, all sorts of things. There was a recent article in, I think, New York Magazine about how a lot of content creators are finding ways to get dash and body cam, and they target a specific group. They seem to have had a lot of views if it is younger women getting DUIs, for example, and they post that online, these body cam and dash cam footage, and then the way TikTok works, if it's a certain length, they get money for it. So they're profiting off of the dash and body cam footage that they get from agencies in other states. So Pennsylvania, you're not going to see that, but it is something that other states have much smoother access to. One example, just recently, this month, Chambersburg Police Department increased their fees from a flat fee for any kind of body cam for $100 to $125 an hour. So just an example of how that has been done recently. Okay, skipped one. Okay, so one other thing is that there was another change recently. We have not seen any since 2017 successful efforts to force agencies to release body cam and dash cam. But recently, in the past year or so, we've seen 2 successful cases, one in the city of Lancaster, which didn't have a lot of details in the decision, but another one was, this is the most sensitive thing. All right. Guys are getting all the heads up here. All right. All right. All right. So then the other one, this was a case, as I recall, where there was someone stole a police vehicle in Ohio, crossed the border into Pennsylvania, and the thief was shot and killed by law enforcement. And someone asked for the body dash cam from that incident in Pennsylvania. And state police said, no, it's an ongoing investigation. We're not going to release it. And the court said, no, this is over. The person is deceased. There's no evidence of an ongoing investigation. And there was footage from people on the ground, citizens who were filming this. There's really nothing you're going to be revealing. And there were no safety concerns that were specific enough to go through with that. So that is something that we did see. Where there has been a slight change. I don't know if this is going to be a new thing, that there'll be a lot of successful court cases trying to get these records, but it's just interesting. There's one in November and then one in January. A couple questions. Can a requester ask to view the dash cam footage and record it about themselves? I'm not sure, without paying a fee. I don't know, Judith, because we don't involve ourselves with that. I'm sure they can ask, and it'd be perhaps something you could consider, but I'm not sure the specifics on that. If an agency doesn't have the capability to blur out, could they deny the request LASIK? Again, I'm sorry, Julie, I wish I could be more helpful, but you may want to talk to your district attorney about that. Because we don't deal with it, I don't want to give you any false information. We did that. Okay. Someone had asked for this, so I just put this here. Again, this is not our area, but I wanted to mention it. There was the Crime Victims Act of 2023. The avenue for victims or their representatives to seek access to certain police investigative records otherwise barred by CREA. The information is to be directly related to a civil action or necessary to investigate and prepare civil actions. This created a way for certain people, victims or the representatives, to access records that are otherwise prohibited. This is completely outside of our world, the right to know law. Any appeals are filed through petition for review with the court, not us. If you have more questions, I would ask the DA or the Attorney General's office for that. Okay. Now, I know that you all may not deal directly with 911 calls and all of that, but I think Pennsylvania has a kind of unique situation, just like with bugshots and with body cam, that I just wanted to talk about it briefly. It gives me a chance to go back to memory lane. Growing up in Virginia in the 1980s, one of my favorite shows was Rescue 911. With the great William Shatner, who is still alive. I think he's in his early 90s. And, growing up in Virginia, I had no idea that there probably are very few, if any, Pennsylvania 911 calls featured on this great classic American show, because Pennsylvania puts a lot of limits on this. 911 recordings, transcripts, and transmissions are explicitly exempt from the right to know law. So in some states, I think we proactively put 911 recordings up on a website or something. But in Pennsylvania, you have to go a different mechanism to get them, because agencies can deny them. Only reason they can be forced to do it if the court said so. An agency has the discretion. They can decide, you know what, I think I'm going to release this. Or the courts can say, you know what, the public interest in this incident of the recordings outweighs the disclosure, the risks of disclosure. And if I was talking to you in person, I would, let me ask, put in the chat if you think you know what happened a few years ago that led to a lot of requests all across the country wanting 911 recordings in Pennsylvania, and it was forced to be released. Put in the chat if you can think of it was a huge international weed history book story occurred in Western Pennsylvania in 2024. Does anyone have any ideas? Yes, Brian, you're right. So that was the first time we were aware of a successful attempt. And this is where the county officials denied the request because of that exemption. And it says part of a criminal investigation. We upheld the denial. And that sounds a little bit more like we upheld the denial, but we really don't have any authority to do anything beyond what the county says. We're just kind of passed through to the courts. And the judge eventually ordered release given the unique historical circumstances of that incident. And again, this is something where we don't have the authority to compel an agency to release anything. And this is one where the identity of the requester, it does not matter. Even if it's you're the one who called in or your kid who called in, it's irrelevant. And just kind of like, typically the identity of a requester does not matter, as I mentioned, and that's the way it is in the whole right to know law. You can't say, well, those are my kids' records, I want them. But I want to share one kind of more amusing story, at least for outsiders, where the identity, a rare situation where the identity of the requester did matter. And in this example, there was a woman who had a pet kangaroo, which is interesting, raises a lot of questions, and the State Game Commission took the kangaroo away from her. She was quite distraught, and she attempted to break into the facility where the kangaroo was being kept. And they then moved the kangaroo to a secret location, and she did a right to know law request to see if she can get records that would indicate the kangaroo's location. And the agency listened. She poses a threat to the security of the building, the safety of our employees. Look at what she's already done. And we said, yeah, that's right. And the courts upheld us. And the result being that the kangaroo, as far as we know, is still in a secret location, an unknown location, and its protection program, enjoying the great life somewhere in Pennsylvania. So sometimes in very rare circumstances, the identity of the requester does matter.
All right. So now I'm going to go over some general tips and best practices here. Most of this will be broadly applicable to all kinds of agencies, but so that this will cover a whole variety of things here. But first, real quick, a question from Sean. You asked who is responsible for determining whether or not the law enforcement records are subject to RTK requests. So many police departments have their own open records officer, some don't. This is something that varies. We see from municipality to municipality. Some municipalities, the open records officer for the municipality responds on behalf of the police department, and in some cases they don't. It's not even just necessarily some smaller municipalities. Some larger municipalities even also just route everything through their open records officer. So we've seen sort of both ways of handling it in that situation in terms of who is ultimately responsible for responding. But either way, if it comes up on appeal, then, evidence from the police department may ultimately be relevant in the appeals process. So here, I'll go on to my first slide here on tips and best practices. So something that's important is for the agency to have an open records officer who is trained and on the ball. So, being presentations like this is already a good first step. Somebody who can respond to requests in a prompt manner, catalog them well, knows who has what, or is able to reach out to determine who has what and things like that. You'll also want to have a backup if possible. I know some agencies are very, very small, but in most cases you want to have a backup, someone who can handle things like assisting when there's a substantial workload related to requests, or somebody who can invoke extensions when the open records officer is out of the office or things like that. That is a really important and a good thing to have it's always good to have a little bit of redundancy in your system. It ensures things don't get missed. That's something that we really recommend, and those alternates can even be listed in our database so that there's multiple contacts for people. That can just help prevent things from slipping through the cracks. It is important for agencies to always respond to requests. So if you receive a request, you want to ensure that it is logged and you know when your deadline is and things like that. These are important things to have here for that. And then another important thing is to follow your retention rules. So this means you want to retain the records that you need to retain and not retain things that you don't need to retain or that are unhelpful for you to retain. Having clarity on what kind of records you have and don't have from the get-go can make the process of searching for things a lot more straightforward and can make the production more straightforward and save you time, as well as, just sort of help you ensure with compliance with all sorts of other types of things. So we have another question about redaction of body cam footage. So unfortunately, like Liz said, that's a bit of a difficult thing for us to comment on. We have a page of some general information on our website about Act 22, but unfortunately, it's not something that we can get much more guidance on than we already did. I got it a little bit ago.
Okay, sorry.
But the timeline for the requests, you're right. It's when the open records officer receives it. That's sort of how it's laid out. It's a little bit of a difficult situation, but generally speaking, yes, it's going to be when the open records officer receives the request that the 5 business day deadline starts. As for quickly on the Red Rocks hail incident, So that particular case was under Colorado law, so it's just a bit of an example, but in general, records on a personal cell phone can be subject to the right to know law. It really depends on whether or not they pertain to agency business, but this is substantially so. A member of a board or something like that cannot evade public records law just by conducting their business on a personal email or personal cell phone, right? So so that's sort of how that is sort of set up to work. I will have to go on here in just a moment, but just very quickly, you can use the same form to update the open records officer information as the deputy. Unfortunately, I do have to get through my material here. If I'm not able to get back to your questions, and I will try to circle back around, but I will note that we will have our email and phone number here at the end. So if I'm not able to get to your question or I'm not able to answer it to your satisfaction right now, then you can always reach back out to us. So here, an important thing that I think some agencies miss that can be really good is to communicate with the requester. So you can ask questions to help really understand what it is that a person is seeking, to clarify it or narrow it down. Sometimes people do not know exactly how to articulate what they're looking for, or they're not 100% sure what universe of records will contain the information that they need. And so sometimes some communication can really help clarify that, and that can save you time in terms of parsing and searching, and also can save them times in terms of getting what they need faster. But it is important to note that you cannot require a reason why they want the records. So this is something that we talked about, but in the course of that communication, you can't require them to tell you why it is that they're looking for something. And an important thing in the context of all of this is that everything should be, conducted in writing or memorialized in writing as much as possible. So, it is important so that, the requester and the agency are on the same page in terms of what's available, what's being sought, and things like that. But also so that if there's an appeal, there's clear documentation of if the request was narrowed or if an additional extension was granted. We all have that for the purposes of the file. So the right to know law here is not a confidentiality law. So you can often put commonly sought records on your websites, meeting minutes, budgets, contracts, policies, purchasing documents. That way, a member of the public can just find that information on your website. They may not need to make a request at all. And if they do make a request, they can generally just be directed to a publicly available website. So that is something that can be done. Real quick, while I'm looking at some of the questions, and I'm sorry, we have a lot of questions, and I'm trying to get to the ones that I can. In terms of responsible for who is determining if a requested record is subject to the right to know law, that can be a matter for open records officers and potentially solicitors. That's going to be, the open records officer is the point of contact for a request, but you can involve your solicitor or other officials to make that determination. That's about as specific as I can get for that. The slides, generally speaking, we do post those on our website alongside where the videos are. So those can be available for printing and things like that, or we're reviewing on that. So I'll move on here real quick. One thing, and as we mentioned before, the exemption categories of the right to know law alone don't prohibit the release of records. So there can be situations where you may have something that may be facially exempt, or it may not exist in precisely the form that it's being sought. But that doesn't necessarily prohibit you from providing information, and that can obviously help members of the public get information that they believe is in the public interest. But it can also just help out your agency in the long run in terms of providing clarity and evidencing good faith and things like that. So, of course, as we said, you need to be careful. There are other laws that render certain things prohibited for release or confidential that you need to keep in mind, obviously particularly relevant for law enforcement agencies. But for some sorts of things, you may make the determination that public interest can outweigh the government agency's interest in withholding information. So we had a situation where a resume for Liz was requested, and we didn't have one on file because of the nature of the appointment procedure for the Open Records executive director. But the decision was made that it was in the public interest to provide information about the experience and things like that for the executive director. So some information was put together and ultimately released for relevant experience and things like that. So that was a situation where, conceivably our office could have argued that the record didn't exist, but the decision was ultimately made that there was a public interest in providing some of that information. So obviously every situation is different, but there can absolutely be situations where providing some kind of record of information that may to some degree exceed your strict legal applications can be useful and in the public interest. So conducting a good faith search is very important. The agency open records officer must inform potential custodians of records. This can include people like contractors as well as employees. So if you're looking for emails or something like that, an open records officer is going to want to reach out to those people who may have the responsive records. And they'll want to obtain those potentially responsive records from those people. And I do put an emphasis here on potentially. It's good for if a person is not quite sure if this or that item that they have is responsive to the request, it's good for that to still be passed on to the open records officer. The open records officer can ultimately evaluate whether or not it's covered, conceivably even the agency solicitor, depending on the nature of the process there. So they want to have those things sort of gathered from the various custodians within the agency who may have potentially responsive records. And then, of course, you can determine whether or not the records are public, whether they would be subject to redaction, certain items being withheld, things like that. So it's very important to begin with that strong foundation of a good search where you reach out to the relevant people, things like that, and gather all of that information in order for it to be properly reviewed. There are some situations where bad faith from an agency can be a really serious problem. So we have had some cases in the past where there was, evidence that a good faith search was not conducted or that an agency failed to produce records or altered records and things like that. So obviously those can incur financial penalties, which can be imposed by the courts if an appeal ultimately makes it to that stage, and of course can involve costly legal fees. They undermine public trust, things like that. So those are some important considerations. A few things here. One, about any and all requests real quick. So specificity is a pretty complicated legal issue. Under the right to know law, you're correct that there can be situations where a request can be denied as insufficiently specific. We have an FAQ item. So if you go to our website, we have an FAQ item that includes a worksheet on this. And we even back in 2024 had an entire training devoted to that topic. It can be pretty complicated determining what is sufficiently specific. And I can't really get into it here, but you can refer to those resources on our website. And also with the 5 business day clock, you're correct. It's sort of the 5 business day begins. The first day is the day after the request is received for the purposes of calculating that deadline. All right, so I will move on again here real quick. In particular, with respect to the appeals process, when you are denying a request or explaining why a record is not being provided, you want to avoid a conclusory statements so that you don't want to just a conclusion. You want to show the facts that underlie the conclusion. So we have some good examples here. Rather than just saying that an email doesn't exist, you can say why it doesn't exist or provide more, that factual information about the search that was conducted, things like that, the retention rules. And similarly, with respect to exemptions, information regarding, that sort of indicates why the exemption is applicable, not just that the exemption is applicable. So here, as we start to wrap up a little bit, I will just make brief mention of these additional resources. So like I said before, you can go to our website listed here. We have an FAQ on there that contains a couple dozen items that includes some case citations. Like I said, that specificity worksheet is also linked on the FAQ on the website. You can find recordings of previous trainings as well as this one will make its way up there eventually. We have a searchable database of our prior cases, and we have agency guides. We have, including that Open Records Officer guidebook. We have templates and various other resources that can be really useful. We do offer these virtual and on-site trainings. So if you are interested in setting something up like that for agencies in your area or something like that, you can reach out to us or use the form on there. And you can also call us here, and we try to get back and respond to messages as we're able, both via email and via the phone. So like I said, if I didn't get to your question here, as those were coming in, I do apologize. I was trying to sort of keep a good clip here. But if I didn't respond to your question or you need clarification about any of those answers, you can reach out to us there. Okay.
And also we have, again, you can watch this one. We also have a couple other ones coming up, the basics of the right to know law. So that goes into much more detail, not focused on law enforcement, about the right to know law, every little step. So if you want more in depth, please join us. You can watch the recording. And then, well, we don't have jurisdiction over the Sunshine Act, which is open meetings. We do offer training on that, so you can do the same there. And Jill had asked a question about, she says, from my understanding, there's an exemption for everything. Oh gosh, no, I can't see it, Jill. And in terms of what's about the blotter, we can't really say yay or nay. We're not allowed to give legal advice and say, yes, you're exactly right. I would just say go to our website and type in police blotter in our search for record, or our whole database of all of the decisions we've ever made, and you can find some information about that. All right, Bryn has a question. If a requester doesn't respond after receiving a final response with associated duplication, requester doesn't respond after receiving a final response with associated duplication costs, is the request essentially at a standstill until they act, or can it be treated as abandoned after a reasonable period? In other words, are they able to come back months later and still obtain the records? Or is an expectation of timely follow-up?
Yes, so, and we can point to, there's an item in the act that addresses this, and I believe the timeline that's laid out there is 60 days. I'm taking that off the top of my head, so you may want to double check that. But yeah, you can, and you can require prepayment for very large requests. So, you know, if you expect that a request is going to entail a substantial cost, I believe over $100, you know, you can set up a prepayment before those records are ultimately duplicated, and you can sort of settle up when the records are ultimately provided on the specifics. If there is a situation where fees are assessed, records are produced, but the requester doesn't follow up and the records aren't provided, conceivably in the future, you can deny subsequent requests if for the outstanding fee issue. So I would say you can reference our fee schedule on our website. We have more detailed guidance there. And you can even search previous cases, because there are all sorts of permutations in terms of when a request is received, when fees are received, and things like that. So, you know, that's, you know, you're not necessarily required to hold on to a production indefinitely if a requester doesn't follow up or something like that. Bill asks, can we get a copy of this PowerPoint? This PowerPoint will be posted on our website. Like I said, there's this whole section that all of our trainings are on there. There's a note here. Accident fees are governed by the state at $15, not subject under RTK. So I'm not personally familiar with that exact number, but what I can say is that there is a note in the right to know law, and this is also, like I said, discussed on the fee schedule page, that if there is another statute that governs a specific item, then that will supersede the right to know law fee schedule, even if the record is being public. So if there are other statutory fees, I believe one of the items we make mention of on there was recorders of deeds, you know, have certain fees that govern their records. Those sorts of fees may ultimately supersede the right to know law fees.
There's a question about official police incident reports. Again, we don't like to say it's never public. But if you look in our database, you'll see a lot of denials of those.
Sure. So for emails and electronic records, so you can, so the way that the law is set up is that if the record can be provided in the medium in which it exists, so if a requester is asking for a digital copy, then a digital copy, you know, if a digital copy exists, then it can be appropriate to provide it that way. There are always questions about converting files and things like that, and we can't necessarily get into the details on that. But, you know, we often, for example, may provide the PDF if an email is being sought. If a requester ultimately wants physical copies, then you can print physical copies and charge for that. But if they're seeking electronic copies of records that already exist in an electronic medium, then providing that way is generally going to be the way that you want to do that. Yeah. All right.
Judith is saying, since most police departments use approved state software, the blotter now is electronic. How can a person view records on the blotter if the software can be accessed, except for approved user from the state. There are a lot of interesting cases on this, Judith, at least to us. I don't know if others would find it so interesting. And I'm not speaking generally about, specifically about this, but I'm generally saying our office in the courts have basically said, if you have a record that is public, you should find a way to give it to the requester. You know, there was one point when they said, oh, we have to, there's one case where someone said, we have to pay a lot of money to our vendor to get those records. And our office in the court said, well, that's not the requester's fault for, your contract being created that way. So there are a lot of interesting cases, so I don't want to get specific on this, but generally making a screenshot or something like that is what you would have to do in that situation if it is a public record.
Sure. So, yeah, so if there are, we have a few more minutes potentially. So if there are any more questions, you can send those to us now. Okay. So here I'll read this out here from Kelly. If an incarcerated person sends in numerous requests and the response is not accepted by the prison, person keeps filing appeals stating they're not received. So there's a little bit of information that I can say here. This can vary depending on the institution in question. So I would say, I mean, not to get too into the weeds on this, but there are different ways of sending mails to the prisons. Some attorneys and people like our office have a sort of a control number to send legal mail directly to inmates, and in other cases, they need to be for DOC, at least for the State Department of Corrections. Other mail may need to be sent to their Spark Communications vendor that does mail scanning for them. So I would say if you're having difficulty getting mail to an inmate, you may want to reach out to the Department of Corrections directly or to the SCI. They may be able to tell you how you can send that mail through. For county prisons, you may want to reach out to them directly, but all I can say is, it's a little difficult. Mails with inmates can sometimes be difficult, but if you're having issues, you may want to contact the prison in terms of how to get that through to them.
Pam has a question, I'll read. Is it recommended that agencies have an open records officer and a police open records officer? I'm not sure how other municipalities do this, but we just have one who works with the chief to review and ultimately respond to all requests. I could make arguments for both, as long as they're both fully trained and know the ins and outs. I think it depends on the size of your police department and your municipality. So Pam, I can't offer a golden answer to that. I would maybe talk to colleagues in other municipalities and see what they do. I think I've seen it both ways. As long as it's a smooth operation, I think both can work.
Yes, to the best of my knowledge, and please don't quote me on this, but I believe Philadelphia, they have their own, and in Pittsburgh, they don't. So, it can be all sorts of different agencies do things different ways. And obviously with, consolidation of local police departments into regional police departments, that's been happening. Obviously, those types of agencies will generally want to have their own if they're not one-to-one associated with a municipality, but, any kind of arrangement can work.
And just as a note, as we're waiting to see if there's more questions, if there are things that you are frustrated about the right to know law in terms of things you are bound to because of the law, reach out to your state rep or your state senator or the governor, because there's always talk of reforming it. It hasn't happened, but I was just at a hearing yesterday when they're talking about all sorts of changes to the law. So we'd be happy to hear your frustration because you all are on the ground and we want to know what's going on. But if you'd like to see changes, reaching out to the governor or the legislature is your best avenue. Is there an official training class or course for someone to become an official right-to-know officer? Tracy, that sounds like a great idea, but there is not one. It's just Dylan and I here trying to answer questions as best we can. Can you post a link to this specificity worksheet? Yes, we will find a way to do that, Christine. Do you have a police department policy examples on your website? I don't know, Steve, if we have examples, but again, if you search our database, we call them final determinations. Type whatever it is that you want to look for, like mugshots or shift rosters or some type of policy. I would suggest just doing that to look for examples. That's what we give you anyway. Just a few more minutes. You guys have really good questions. Thank you. All right, seeing no questions, Please join us in April and May if you'd so like. And we will do this again probably in the fall, so look out for that. Have a great rest of the day.
All right, thank you. Yes, like I said, you can reach out to us at those contacts if you have further questions. This video recording will be posted on the website. You can reach out to us either with questions related to this presentation or on other issues, and we can do our best to respond as we are able. So, all right. Thank you, and everyone have a good rest of your day.